To all of you. Very good evening. Okay. Hi, Ovia. Good evening. Good to see you here. All right, everyone. Okay, so today's session is going to be a very light one because we are going to discuss transfer transmission. Not very important for exam, but there are a few sections on which I have observed that recently many questions have been asked. Students, very soon I will also be uploading, maybe by tomorrow evening. Hi, Ashwath. So, students, by tomorrow evening, I will be uploading a list of all the important sections, okay, on which questions are generally asked and on which questions can be asked in your attempt. All right, so I will be uploading a list of all the important questions for exam. So I will share the link on YouTube as well as other WhatsApp, etc. So today, let us discuss the most important topic, the most important section from the chapter transfer and transmission, and we are also going to cover debentures. Okay. So let us discuss. All right. So yes, sometimes students leave this chapter because they feel it is very easy, or the questions will not be asked in the exam. But this is very, very important as far as section 58 is concerned, section 59 is concerned. So please highlight the important sections from this chapter. Questions may be asked on section 58 and section 59. Okay, these are the most important sections. Forge transfer is generally asked as a short note. It's been a very long time since question was asked on forge transfer. So I'm expecting that this time a question may be asked. Also important for case based question. Section 56. Yes. Transmission important for case based questions. All right. So let us continue our discussion of share capital and debentures. So in today's session, we are going to cover transfer and transmission, and we will also discuss the most important sections of debentures. All right. Getting a few messages from students. They are asking whether recording will be available later because everybody is studying different chapters now and different subjects. So they are all asking whether we can watch this lecture later. So let us discuss the concept of transfer and transmission. Now, what is the difference between transfer and what is the meaning of transmission? The word transfer actually indicates that this is a voluntary act, whereas transmission happens by operation of law. Okay, transfer is actually a voluntary act, whereas transmission operates, it happens by operation of law. Okay. As per section 44, transfer means it's a voluntary conveyance of ownership from one person to another. Like I want to cease to be the owner and I will transfer it to someone who wants to become the owner. So I have a small chart for you as to how the entire procedure takes place. I also have a detailed list of section numbers. Yes. So these are the section numbers which are important for exam from this chapter. Not important, but they are all section numbers. So you will be able to find a list of the sections. Yes. So we have section 56, subsection 1, subsection 2, 3, 4. So this will give you a list which you can refer for exam, and it will help you to revise all the section numbers before exam. Okay. So this I will share it with you later. You can pause the video and write it. You can come again and write it. Now, what happens in case of transfer? See, students, the first thing that you should remember over here is that this chapter is only from the point of view of physical. When the shares are in the demat form, this section will not apply only. It will apply only to those. Uh, it will apply to only those securities which are in the physical form. Now, Mr. Ram wants to transfer shares to Mr. Sham. Mr. Ram is no longer interested in remaining the shareholder. So, he wants to transfer the securities in the name of Mr. Sham. So, what is the procedure? Firstly, they will have to completely fill, sign, and stamp SH4, which is nothing but the transfer deed. So, it is a form which you need to sign, and both the transferor and transferee will sign. We will mention the details of the transferee, his name, address, occupation, if any. So the transfer deed, which is filled completely, it is signed, it is stamped. You have to pay stamp duty on transfer. Stamp duty is a percentage which you will find in the stamp act of your state. So it will be stamped, it will be dated. Okay, that transfer deed in form SH4. Along with that, we will also have to submit a share certificate or letter of allotment. Now, what happens is when you surrender your letter of allotment, then you will get by the means of letter of allotment, you can transfer shares. So although I have not received the share certificate, I can still transfer shares through the, I can still transfer shares to the letter of allotment. So if I am transferring the securities even before I receive the share certificate, I can do so with the help of letter of allotment. So the transferor will fill the transfer form, both of them will sign. He will, along with the transfer form, attach the share certificate, or if you have letter of allotment. So everything will be submitted to the company within 60 days of executing the transfer. This can be asked as MCQ. Okay, so you need to remember that within 60 days of the transfer, you will submit that to the company. The company will then register the transfer within 1 month. What will the company do in that 1 month? They will remove the name of Mr. Ram and they will write the name of Mr. Sham in the register of members. Okay, so his name will be removed and Mr. Sham's name will be added in the register of members. They will make endorsements on the back of the share certificate. Okay, they will make endorsements in the back of the share certificate. They will give that share certificate to Mr. Sham. So they will register the transfer within 1 month, make endorsements on the back of the share certificate and give it to Mr. Sham. After all this is complete, you can say that the ownership is now transferred from Mr. Ram to Mr. Sham. This is the entire transfer procedure. So I have made a note of it in this one chart. Okay. So what is the procedure? A properly filled transfer form will be submitted to the company. The form will be in SH4, the transfer deed will be in SH4. A duly stamped, executed on behalf of the transferor, complete in all respects. All the details should be filled. Both the transferor and transferee should sign it. Okay, it must be signed by both of them. It will specify the name, address, occupation, if any, of the transferee. It will be signed by both the transferor as well as the transferee. It will be presented to the company within 60 days from the date of execution of the transfer. So within 60 days, that point also should be included. Within 60 days, you will submit it to the company. The company will then make the necessary changes in the register of the members. They will make endorsements on the share certificate and they will give it to the, that share certificate will be given to the transferee. After your name is entered in the register of members, you can consider that the transfer is complete. One important point which can be asked as MCQ Now, see students, when the transferor is transferring partly paid up shares to the company, to the transferee, okay, the transferor is transferring partly paid up shares. Now, whether the transferee is aware that the shares are partly paid up. See, when the transfer form is signed by both of them, when there is signature, we are assured that, yeah, transferee is aware that the shares are partly paid up and the transferee will have to pay the balance amount. But what if the transferor alone makes the application for transfer of partly paid up shares? This is very important for us. Transferor is alone making the application. So how will we know whether the transferee is aware that the shares are partly paid up? So what the company does, the company shall give a notice in form SH5 to the transferee. They will give a notice in form SH5 to the transferee. Are you aware that the shares are partly paid up? Please give a no objection within 2 weeks from receipt of that notice. Give us no objection that you are aware that the shares are partly paid up. You have no objection in paying the remaining. Okay. So if we obtain this no objection, only then the partly paid up shares will be transferred in the name of the transferee. Okay, so we need to obtain the no objection within 2 weeks. Only then the partly paid up shares will be transferred. Otherwise, we transfer and then the transferee says, Arey, I was not aware that the shares are partly paid up. I thought that they are fully paid up. I will not pay. In fact, I paid 10 rupees to the transferor. Why should I pay you more? I've already paid the full face value. So, in order to avoid all that confusion, we give a notice to the transferee, and only when he gives a no objection, we will execute the transfer. Okay. So that was about the transfer. Section 57. Okay, let's do section 57. Again, can be asked as a short note. Sometimes, no students, we feel that this is a very easy chapter. Questions will not be asked from this, but many questions are asked. So these are the important sections, section 57, 58, 59. Punishment for personation of shareholder. Personation means you're pretending to be someone else. Right, on the meaning of personation, personation means you are pretending to be someone else. So I am impersonating a person. I'm pretending to be someone else and I get the transfer executed in my name, or I get the benefit like dividend, etc. of those shares. If any person deceitfully means with intention to cheat, he personates as the owner of the security. Now, the owner of security was Mr. Sharma. And you are saying, yes, I am Mr. Sharma. Yes, so you are personating yourself to be the owner. You are pretending to be the owner of the security or interest, or you are pretending to be the owner of the share warrant. Yes, you are pretending to be the owner of either a security or interest in the company, like beneficial interest. You are pretending yourself to be the owner of the share warrant or coupon in case of debentures. You attempt to obtain the security, interest, or warrant or coupon, or you already receive that benefit, then such person will be punishable with imprisonment 1 year to maximum 3 years, fine ranging from 1 lakh to 5 lakh. So if you're pretending to be the owner, you take the benefits, you take interest, dividend, or you get the shares transferred in your name, you sell it to someone. If your intention is to personate to be someone else, you will be punishable with imprisonment and fine. Section 68, very important. Very important, because most of the case-based questions, theory questions from this chapter are on section 58. Now, the company has the right to refuse the transfer. Ma'am, how come the company will refuse the transfer? Like, how can you refuse the transfer? Yeah, in case of private company, I can refuse the transfer because there is a restriction. It is mentioned in the articles only that the private company is a close-knit company. We have the right to restrict the transfer. Even in case of public company, the transfer can be restricted. Like, I can say the company has a lien on those shares, or the shares are partly paid up. We will not execute the transfer unless the shares are made fully paid up. Okay. So private as well as public company, they can refuse the transfer. But law says the instrument of transfer. Now, this is a timeline, okay? The instrument of transfer has been delivered to the company. The instrument of transfer is delivered to the company. See, company, if you want to refuse the transfer, at least inform the parties, give them a notice of refusal with reason why you are refusing their transfer. So we will give notice of refusal. This notice must be given within 30 days. So as soon as the instrument is delivered to the company, if the company is not transferring, give a notice within 30 days. If the notice is given, but the shareholder is not satisfied with the reason, then he can make an appeal within the next 30 days. Arey ma'am, they didn't even give a notice of refusal. We were waiting for 30 days. Now I will get the notice of refusal. They didn't even give a notice of refusal. Then the person, okay, then the transferor or the transferee shall within 60 days, 60 days will be calculated from when? 60 days from the date the instrument was delivered to the company. So within 60 days, they can make an appeal. 60 days will be calculated from the date the instrument was delivered to the company, the instrument of transfer. This is in case of a private company. What about public company? The instrument of transfer, okay, the instrument of transfer was delivered to the company. Now, as I already informed, even in case of a public company, we can refuse the transfer. No, we cannot transfer partly paid up shares. No, we cannot transfer shares on which lien is there. We can refuse. But at least give a notice of refusal. If you want to refuse, at least inform us within 30 days. Okay, so as soon as the instrument is delivered to the company, within 30 days, inform us about the refusal. So we got the notice, but we are not convinced with the reason. Then within 60 days, we can file an appeal. Okay, appeal can be filed. Ma'am, they didn't even give a notice. We were waiting for 30 days. Then as soon as the instrument was delivered to the company, within 90 days from the date the instrument was delivered to the company, within 90 days, we can file an appeal. You may feel that, ma'am, this is sounding too technical, but I'm telling you, students, many questions are asked on this. Section 58 is extremely important for it. Many questions are asked. So that was section 58. Okay, this is the procedure I discussed this with you. Now, appeal was made to the tribunal. Yes, appeal was made to the tribunal. The tribunal will either dismiss the appeal. This is option 1. The tribunal will say, no, I don't accept this. This appeal is not correct. Company is correct. So they may either dismiss the appeal or they may order the following. Either your appeal will be dismissed or the tribunal will ask the transfer or transmission to be registered by the company within 10 days of the receipt of order, or they will say you make rectification of the register and also direct the company to pay damages. Default will attract penalty. So this order of the tribunal will also be written in the exam if a theory question is asked. Can be asked as a theory question. It can be asked as a theory question. Rectification of the register of members. Now, what is the meaning of rectification? Rectification means to correct the mistake. Okay, there was some mistake. We are trying to correct that mistake. We are trying to correct the error. So maybe, without any reason, my name was entered in the register, or without any reason, my name was removed from the register. So we can get it rectified. So rectification, if the name of any person without sufficient cause means bina wajah. Okay, bina karan. You can write that also, bina karan. It means without any reason. Without sufficient cause means without sufficient reason. Without any sufficient reason, either my name was entered in the register, after it was entered, it was removed from the register, it is omitted from the register, there is unnecessary delay in entering in the register, then the aggrieved party may make an appeal to the tribunal or any competent person outside the court if it is in case of a foreign register. The tribunal, after hearing the appeal that Array, my name was removed, or it was, by mistake it was entered, again we will either dismiss the appeal, or we will direct that the transfer or transmission shall be registered within 10 days, or rectification may be ordered and the company will be ordered to pay damages. So these are the keywords. What is the meaning of forged transfer? Can be asked as a short note, but it can also be asked as a case based question. If you see my compiler, you will find that there are many case based questions asked on this concept. Okay, what is the meaning of a forged transfer? Forgery, it means copying someone else's signature. There is some network error. Okay, there is some. Okay. I don't know. There was some error. The network, I am not very sure. Okay. I think you guys must have missed part of it. Hopefully that appears in the recording. All right, let us continue. The students they're able to see me. Yeah. So we were discussing forgery. Yes, forgery. All right. So forgery means copying someone's signature. Yes, forgery means copying someone's signature. Okay. Chaitanya. Now I think it is fine. Okay. So forgery means copying someone's signature. Forgery is a nullity, it is void, ab initio. Please remember these words, these are the key words. You need to mention this in your answer. So, forgery is a nullity, it is void, ab initio. Now, pay attention to the example. In case a question is asked in the exam, it will be on this example only. X gave his share certificate to the broker. Foolish person. Okay. X gave his share certificate to a broker. The broker, on a transfer form, forged X's signature, transferred the shares in the name of Y. Okay, so he forged X's signature, sold the shares to Y. Y then sold the shares to Z. I have already prepared the example for you. So X gave a share certificate to the broker. The broker forged X's signature. He transferred the shares to Y. Y then sold the shares to Z. X, the true owner, came to know about this transfer. He said, I never transferred the shares to Z. So he filed a case against the company saying that, how did you execute this transfer? My signatures were forged. I never entered into this transfer. Now, the company will have to keep the shares in the name of the true owner. So the company cannot deny that X's signatures were forged. Forgery is a nullity. Nullity means it has no legal effect. It is void ab initio. This transfer is void. The company will have to keep X as the owner. So X will remain the owner. His name will be restored in the register of members. In case the company had declared dividend during that period, he will also be entitled to dividend if it is declared during that period. So X's story is over. The forgery turned out to be a nullity. It was void ab initio. X got back his shares. His name was restored in the register of members. Okay, his name was restored in the register of members. So his story is over. What about Z? Now Z, the innocent buyer, he paid for the shares. Now you are telling the shares cannot be registered in his name. Z will claim compensation from the company because the company gave him a share certificate. Share certificate is a proof that you are the owner. Now the company is saying, no, no, we gave the share certificate by mistake. You are denying that. You will have to compensate the innocent buyer. Now it is not the company's fault, no? The company will then recover the compensation from Y. Why? You did not check that X is not signing, it is a forgery. So you knew about all this. The company will recover compensation from Y. Y will recover compensation from the broker who actually orchestrated this fraud. Okay. So once again, X will be the true owner of the shares. His name will be restored in the register. He will be entitled to dividend if any. Z will claim compensation from the company. The company will claim compensation from the transferee. Transferee will recover the compensation from the person who has actually committed this forgery. So this is the entire flow of forged transfer. Okay, the entire flow of forged transfer. The only part which remains to be discussed is transmission of shares. Now, transmission is by operation of law. It happens automatically. It happens by operation of law. So, in case of death, okay, in case of death, the shares will automatically be transmitted to the legal representative. In case of insolvency, they will automatically be transmitted to the official receiver or assignee. And in case of insanity, they will go to the guardian. Okay, they will go to the guardian. They will be transmitted to the guardian. Now, like in case of transfer, you have to submit a transfer form. Your form etc. is not required. Just give an intimation of transmission. So in case X was the owner of shares, okay, he died. X died. The shares will automatically be transmitted to the legal representative. The legal representative will give an intimation to the company that, listen, shares have been transmitted in my name. I will decide whether I want to become the member or I want to transfer the securities further. I will decide. If he decides to become a member, then he will send an application to the company along with a share certificate and succession certificate. Succession means he will give a proof that X had, I have succeeded the shares from X. If he doesn't want to become the owner, he can transfer the shares further. So X doesn't want to be the owner. Sorry, X was the owner, right? The legal representative. Legal representative does not want the shares to be in his name. He can transfer the shares to B. Now the question arises, if X was the owner and then he died, legal representative has not transferred the shares in his name. He wants to transfer the shares further. Now the question arises, he's not the owner. He's not the owner. But will the sale be valid? He's not the owner. So will the sale be valid? How can a non-owner transfer a good ownership title? Law says it's an exception. Even though legal representative is not the owner, the sale will be valid. It's an exception to sale by non-owner. It's an exception to sale by non-owner. Okay. So yes, the sale will be valid. Even though he is not the owner, he can. What are the documents to be submitted? He will deliver a duly stamped and signed instrument of transfer along with a share certificate and succession certificate. So a duly stamped signed instrument of transfer, because you're transferring the security to some other person. In case you want to become a member, just give an application. But in case of transfer, duly delivered signed instrument along with the share certificate and succession certificate. Is this important for exam? Yes, this part is important for case-based questions. Okay, so this is important for case-based questions. All right. So what I have highlighted, this part, this is very important for exam. Okay, all this is asked in the exam. This part. Students, these are the section numbers. You can come later and copy this. So I'll just show it to you. Section 56, subsection 1, 2, 3, 4. I have prepared a list so that you can, you can refer this for the exam. And this one. All right, you can come back and write it. So that was about transfer, transmission. Debentures, the initial part, that is types of debentures, etc., that is not very frequently asked in the exam. Only one topic is asked, that is debentures with voting rights not permissible, section 71. Under no circumstance can we issue debenture with voting rights. Ma'am, the articles allow the debentures to be issued with voting rights. Nothing doing. Even if the articles allow, you cannot issue debentures with voting rights. See, they are creditors. They are creditors. How can you allow the creditors to vote and take decisions for the company? Even if authorized by the articles. Even if it is authorized, debenture holders, debenture holders cannot vote. They cannot vote in the general meeting. They cannot vote even if it is authorized by the articles. This is very important. Can be asked as a 2 to 3 mark question. Okay? 2 to 3 mark question. Important, who can be appointed as a debenture trustee? This is important for case based questions as well as theory. Can be asked as both case based or even theory question can be asked. Now, who is a debenture trustee? What is his work? See, the company has issued debentures. They had mentioned that, listen, debenture holders, we will use this money for growth and development of the company. Okay, so that was the purpose for which they had raised debentures. So the debenture holders, they asked the company, Are, it's been 1 year, we cannot see any growth and development. It is happening, it is happening. Next year you will be able to see. But we cannot see any growth and development happening. So whenever we ask the company, they are always saying, yeah, we are on it, we are working. Next year you will be able to see. We wanted to call a meeting of debenture holders, but the company is not paying any attention. We are not getting our interest on time. The company is again not approachable. So what can we do? The debenture trustee, okay, in this case, the debenture trustee acts as a liaison, acts as a middleman between the company and the debenture holders. So, what is the work of the debenture trustee? They will ensure that the dividends are paid, the interest is paid on time, meetings are held on time, grievances are addressed, the company uses the money for the purpose for which it was raised. So, they will act as a connecting link between the company and the debenture holders. Okay. So, who can be appointed as a debenture trustee? We will see later, and who cannot be appointed. So, debenture trustees, they protect the interest of the debenture holders, they redress their grievances, they ensure that the interest is paid on time, meetings take place on time. The trust deed is between the company and the trustee. The trustee will be appointed before we issue the debentures, but the deed will be entered after the debentures are issued. The trustee will be appointed before the issue of prospectus or letter of offer. In fact, the appointment is done before the prospectus or letter is issued, because the name of the trustee is mentioned over there. Okay, so the name of the trustee is mentioned in the prospectus or the letter of offer. Letter of offer is given in case of private placement. So if you are privately placing the debentures, prospectus is for public offer. Even private companies can offer debentures through private placement. Okay, so the appointment happens before the issue of prospectus, but the deed, the agreement happens within 60 days of allotment of debentures. Now, in case of secured debentures, okay, in case of secured debentures, we will create a security or charge in favor of the trustee. Why? See, the company will create a charge in favor of the trustee. It means that in case the company fails to redeem the debentures, the trustee will appoint a liquidator, and this liquidator will sell the assets and they will get money to pay the debenture holders. Okay, so now if we want the trustees to sell this security, the charge must be created in favor of the trustee. Only then they will get the right to sell it and pay off the debenture holders. What if we are not happy with the trustee? They can be removed only with the approval of holders holding 3/4 of the value of outstanding debentures. Let's say that the debentures are outstanding 10 lakh rupees. Okay, 10 lakh are the outstanding debentures. This is in terms of rupees. 3/4. It means those many debenture holders who are holding at least rupees 7,50,000 worth of debentures, if they give their approval, let's say 5 people are together holding debentures worth 7,50,000. So when those 5 people give their approval, only then the trustee can be removed. Okay. Who cannot be appointed as trustee? Very similar to that, who cannot be appointed as an auditor. So a shareholder having beneficial interest in the shares cannot be appointed as trustee because he will not think from the point of view of debenture holders. He will think from the point of view of shareholder only, not debenture holders. Promoter, director, KMP, any other officer or employee of the company, associate, subsidiary, holding, cash. Okay. So if you are the promoter, director, KMP, any other officer or employee, even the officer or employee cannot be appointed as trustee. Of whom? Company, associate, subsidiary, holding, cash. Acha. Any relative of these, any relative of the promoter, director, KMP of either company, associate, subsidiary or holding cannot be appointed as trustee. Creditor of the company, even if he is a creditor of 100 rupees, you cannot be appointed as a debenture trustee. This can be asked in case-based question. Creditor is holding, creditor has to recover only 500 rupees. Cannot be appointed as trustee because you will not think in favor of the debenture holders. You will first think of your interest. Any person who is indebted to the company because he is biased, he has to pay money to the company. So he will obviously think from his point of view, not the debenture holder's point of view. You are indebted either to the company, associate, subsidiary, holding, or fellow subsidiary. Cash, a fellow subsidiary means subsidiary of a subsidiary. Anyone who has given guarantee, you are acting as a surety for the repayment of the principal, interest in respect of debenture. You cannot be appointed as a trustee because you have given guarantee. You will first protect your interest. Now, the company has promised the debenture holders that I will pay your principal amount along with interest. I will pay your principal along with interest. S has given guarantee to the debenture holders. Arey, don't worry, debenture holders, company will pay. I am there now. I give guarantee. How can such person think in favor of the debenture holders? How can he be appointed as a trustee? How can? Because if he has given guarantee for the company, he will never point out faults in the company. He will never show that the company is defaulting. Because he has given guarantee. If he shows that the company is defaulting, he will have to pay. Any person who has pecuniary relation, pecuniary means financial, with the company amounting to 2% of the gross turnover or income, or rupees 50 lakhs, or any prescribed amount. Nothing has been prescribed. Whichever is lower. So what should we do? Step 1. Calculate 2% or more of the gross turnover or income. So calculate 2% of the gross turnover or income. Compare it with 50 lakhs. Now let's say 2% comes to 1 crore. Compare it with 50 lakhs, whichever is less, means 50 lakhs. So if your financial transaction, okay, if your financial transaction is more than 50 lakhs, you cannot be appointed as the trustee. Okay, you cannot be appointed as a trustee. So financial interest of 50 lakhs or more. So 1 crore, 2% of the turnover is coming to 1 crore. Compare it with 50 lakhs, whichever is lower. So 50 lakhs is lower. If your pecuniary relation, if your financial relation is more than 50 lakhs, you cannot be appointed as a trustee. Students, I have prepared a table. Okay, I have prepared a table for debenture redemption reserve, DRR. Okay, DRR. What is this reserve? It is a reserve which is used for redemption of debentures. Wow. See how we linked everything? DRR is a reserve which is used for redemption of debentures. So this is a specific reserve. It can be utilized only for the purpose of redemption of debentures. But this merely represents a reserve. This is not actual money. That actual money is in the form of DRF, that is Debenture Redemption Fund. This represents actual money. Now, in case you are all India financial institution or you are a banking company, all India financial institution is backed by the government. So if you are an all India financial institution or you are a banking company, you may be issuing debentures through private placement or public issue. No need to create DRR, no need to create DRF, because the chances of you failing is very less, because they are regulated by RBI. So the chances of failing is very less. They will redeem. That is why no DRR, no DRF is required. If you are a public financial institution, you may go for public offer or private placement. You need to create DRR same as NBFC. Right now, NBFC are not required to create DRR or DRF. If you are a listed company, except these, okay? If you are going for public issue, okay, if you are going for a public issue, this, there is a small change here. This is application. So if you are going for public issue, so DRR is not required, but DRF is required, but it is only 15%. And why so less? You said that we need money for redemption, but just 15%? Don't you think that it is very less? Yes, it may be less, but it is an organized company. Do you really think that they will not make any provision? Of course, they must have provided. But this 15% is just like, in case you have not provided anything, at least provide this much. 15% of what? 15% of the amount of debentures maturing during the year 31st March of the next year. So if I am in the year 2023-24, I will create DRF of 15% of the debentures maturing during 24-25. That money which I am keeping aside will be invested as deposits in scheduled bank, unencumbered securities of the central or state government. If you are not able to remember all this, just say securities of the central government, state government. Okay. So, unencumbered securities of the Indian Trust Act. Others need not create DRR, but DRF is required. If you are unlisted companies and you are an unlisted NBFC or HFC housing finance company, nothing is required, but other unlisted companies, DRR is required, DRF is also required. There is actually nothing to explain in this, but you just need to memorize the table. Okay, just need to memorize the table, and I think your work is simplified. Explanation is required when everything is theory. Here I have simplified the provision for you. Simply remember this for exam. Okay. So students, with this we come to an end of our revision on debentures. I have covered all the important provisions. This is not very important for exam. It is very rarely asked. DRR, DRF is hardly asked. But many questions are asked on debenture, trustee and debenture trust deed. That is very important for exam. Tomorrow also we will be having a session. I will be covering one very interesting and important chapter of charge and deposits. Okay, so we will be covering charge and acceptance of deposit. Both are extremely important for exam. Minimum 5 to 10 marks questions are asked. If you see the trend, every year they have asked questions from charge and deposits. So tomorrow we will be covering one very important aspect, charge and deposits. Today's session was a very short one because the topics were such. On Monday, okay, on Monday I will be covering FEMA, because many students were like, ma'am, we are not understanding that. You simplify the topic so much. So Monday we will be covering FEMA. So please attend Monday's lecture, because everything in FEMA will be discussed and it is important. For example, the new chapters have weightage of around 30 marks. So Monday we will meet for FEMA, and let's wrap up today's session. I hope you enjoyed. Yes. So I'll see you on. I will see you tomorrow at 7, and then directly on Monday. Sunday we will not meet. Sunday you can study some other subject, but Monday definitely. All right, students. So I take your leave now. Good night. Take care and keep studying.